Hello, how are you doing? Welcome to Lawyers Infohub. It's always a pleasure to create content on this platform. This is Lawyers Infohub. It's a platform where we share legal tips. We invite other people to share their experiences aimed at helping you to become a better lawyer, achieve excellence in practice, and to simplify legal concepts for ease of understanding. If you're yet to subscribe to the channel, please do hit the subscribe button. Share this video. Also, like our videos. There are lots and lots of videos on the platform that will help you to become a better lawyer, that will help you increase your knowledge and to help you get understanding on certain areas of law that you're confused about. Today, so we're looking at instances where the court can grant cost. Now, what is cost? Cost is a monetary award given by the court against a party in a matter owing to either disobedience of court rules, failure to do certain acts within stipulated time, for wasting the time of the court, for other acts maybe that are not supposed to, that that is not expected of a lawyer. Certain things a counsel can do which is not supposed to do. The court can also see it as worthy to grant cost based on the application of the other counsel. Now, generally, when costs are awarded by the court, you know, the court will usually give the timeline for payment. The court can order a cost and say payment should be before the next adjourned date. Court can also say payment should be within 30 days, after which interest will, begin to accrue. So in whichever way the court puts it, it's important to know that it is within the discretion of the court to state the amount to be paid, and if there is going to be interest, the rate of the interest. Now, one of the first instances where costs can be granted is when we failure to do acts within stipulated time. If, for example, a counsel is supposed, let's just say the plaintiff counsel was supposed to file an application, maybe in response to an application filed by the other counsel in the matter, and failed to do so within the stipulated time. And over time, the failure of this other party to file his own process has stalled proceedings. The party who has that application can let the court know that it is the delay of this other person in filing a response that has stalled the hearing of the application. In such instance, the court can grant cost and award cost for the day because you came to court and you're not able to achieve the reason you came to court, owing to the failure of the other party to do what he or she is supposed to do. So in that instance, the court can grant cost against that other party. Secondly, if, for example, an application also is being brought by a party and the other party responds, maybe preliminary objection, a motion, just an interlocutory application that entails the court to write a ruling. In writing that ruling, each of those parties might ask the court for cost to say this application is not meritorious or this application ought not to have been brought in the first instance. So in such instance, if the court rules that that application, is unsuccessful or is being, dismissed or struck out or does not have merit, the court can award cost to the other person who responded. Another instance in which the court can grant cost is where, for instance, a party files an application and all the other parties have responded. On the day of the hearing of the application, the party who brought the application seeks to withdraw the application. Now, it has made the other party to spend money in filing the process, time, research time, and all of that, filing, service, all those costs expended and you seek to withdraw the application on the day of the hearing of the application or any other short date for the fact that for the fact that the other party have
Yes, sir.
responded
Yes, he has given me the document.
for the fact the other party have responded and he seeks to withdraw that application, he's entitled to court if he has. The court
Yes, sir.
cannot on their own.
But I need to seek
The
permission
court
from my
cannot
boss.
on their own grant costs without you asking. So when you ask for that cost, the court might
Yes,
ask you
yes, sir.
what is the reason? What is the reason why you're asking for cost? What you state the court that you have filed a response, you have spent money, you have spent time. So that is the reason you're asking for cost. The court can now you
Okay,
now
so
state tell the court
yes, sir.
how much you're looking at, and the court will now look at it, weigh it, and the court will also ask the other party whom you're asking cost against to explain or if he has any response. The other person might say, okay, my lord, I'm conceding to a certain amount, or I pray that costs be in good cost. Or I'm not conceding to anything because my withdrawal of this application is predicated on the fact that this happened, or it was the action of the other party that necessitated the withdrawing of the application. So whatever it is, you have a right to respond when cause is to be is asked against you. So the court allows a party to respond to see if there's a reason why cost should not be awarded. So in such instance, what happens is that when the court weighs it and see that the reason you're giving is not substantiated enough, the court can grant court. It could be, but it cannot be more than what was asked. If a party asks for like 200,000 or 100,000, the court can grant 50,000, or you can even grant that certain amount that the person asks. They say that the court is not the Father Christmas. So it's what you're asking the court can give you, but the court can give you less than what you're asking the court to give you. In the other instance, the court can also agree with the other person who says cost should be in cost. Maybe basically that was the first time the person is doing search, or uh, in the past the court has awarded cost against that person, or that could be other consideration the court may look at in agreeing to that application that cost being cost. Now when the court also delivers judgments or rulings, you might add cost rate, cost of so amount to be in favor of this against this. So in such instance, the court has weighed it, an application, a matter, and at the end of it all, court feels there's a need for financial compensation for damages, you know, towards helping the party or the applicant or the claimant or the person who won the case to recoup. So in such instance, the court can award costs. Now, many people ask when the cost is awarded, is it the lawyer that pays or the client that pays? There are some costs. For example, there's another instance where a party files a frivolous action. As a lawyer, you know that this application you're filing is just to either waste the time of the court or to just arrange the judgment or to just want to do the impossible, you want to attempt the impossible. Or you're being forced or you're being led by your client to let's find something to delay the court or something or something else. In such instance, what happens is that what the court looks at is that you should know as a lawyer, based on your training, exposure, that you were not supposed to file this matter. That you brought that application in bad faith, either to delay the court, to waste their time, not to achieve a certain purpose. So when the court sees that the intention behind your bringing the application, you shouldn't have brought it, was frivolous, the court can fine the lawyer in his or her personal capacity. The court can say the claimant counsel, cause awards costs against the claimant counsel in his personal capacity. We have seen it instances where lawyers have been fined in millions. The court might also just generally say cost against the first defendant or second defendant. In that instance, it's the client that pays. You have also seen instances where cost was awarded against a client, a party, and they failed to pay. The other person in favor the cause was awarded can raise it up to the court to say, my lord, this non-payment of cost is a disobedience to the order of court, because that order with respect to cost is an order which ought to be obeyed. And such application can even cause the other person not to be heard. So the person to whom the cost was awarded in his favor can ask that the right of audience of that other party be what taken away from him because he has failed to obey the orders of the court. So in such instance, you see where the client or the lawyer is restricted or restrained to say, okay, I'll pay after the court sitting, or sometimes even in court they pay, or because sometimes it's embarrassing when you have such in a situation where your right of audience is being denied because you are owing a cost. So be that as it may, however it is, cost can be awarded against the lawyer personally or against the party he is representing. So it's important that things are as a lawyer whose aim is to attain excellence in practice, to always do things at the right time. It's very, very important. You see people who delay. Sometimes these delays may not even be on the part of the counsel, it could also be on the part of the party who fails to bring in maybe documents for you to attach to what you're filing, delay in health, non-availability. There are a lot of reasons. But in such instances, it's important that a counsel reaches out to the other party, to the other lawyer on the other side to explain. Most times, why costs is being asked in court is that because the other lawyer is in the dark as to why you're acting the way you do. So what when you there's an kind of an explanation to the other counsel to say, I'm very sorry, why we have not filed this is because of this. Some are understanding they can, but some are feel well. The law has said that you have 42 days to do this, or you have 7 days to do this, or you have 14 days to do this. Your failure to do that is not my business. So I have to proceed. Some are like that. But sometimes it's important because if an instance for cost arises and you explain to the court, my lord, have explained to my colleague on the issues I'm facing and all that. Court will look at it like this person is reasonable, has tried even beyond before the court, sat to explain his predicament to his fellow colleagues. So such instances can also give you that leeway for the court to see the effort you're making, to see that the right things are done. And when costs are being given, it's important that you try as much as possible to pay them. To try as much as possible to pay them. And sometimes when a cost is being, a party asks for cost, and you know that indeed you caused the issue, or you are the one at fault, you can concede to a lower amount. And depending, the court might just accede to that. You can just concede to what you feel you can pay. Is very important. And if it's not possible and a higher cost is being given to you, explain to your client, look at the reason why the court gave us costs. We were supposed to produce the document, you didn't produce it, I did not file this thing on time. So, and when costs are being given like that, it may also makes those parties to sit up in anything they are doing. They know that if you don't do this on time, there will be a repercussion or a consequence for not acting within time. So granting of cost is at the discretion of the court. I've also seen instances where people apply for review of cost that is granted that is way too much, the person cannot pay. We've also seen such applications where you bring applications and my lord to vary your order with respect to cost made on so day. We have also seen where such applications have been argued and the court looks at it and feel, okay, you're giving me substantial reason on why cost should not be given, or this cost should be reduced. This person cannot pay. This person does not have a job. There are a lot of reasons people have put forward, for review of cost, and we've also seen where it was reviewed. We have also seen where it was refused. So either way, you can choose how to go about it, but the best way is to even avoid the cost in the first instance, especially if it's for all the interlocutory applications, doing the things at the right time. But if it's for judgment, obviously, if you have asked for, if there's need for pecuniary financial uh, uh, awards to be made, the court will definitely make that award. If you're not comfortable, you can appeal. They pay the judgment. Most times, many people appeal judgment, and some other time, just take it as it comes. So it's just part of those things we say in practice. Um, uh, that the fact that you've never been awarded a cause before doesn't make you the best of the best lawyers. The fact that you've also been cause have been awarded against you too doesn't make you a less effective counsel. It's just a situation. But try as much as possible at every point in time to always do the right thing to ensure that you know you abide by the rules, things are done at the right time, no 11th hour rush, because that is why what makes many people get caught in all this cost because they refuse to do what they're supposed to do in many cases. Yeah, so law practice involves a lot of diligence, a lot of hard work. It's not what you just do at your time. There is time to do everything. So if you have any question on this topic or any other topic we have treated on this channel, please send a message, drop your comments. We'll see them, we'll respond accordingly. If you are yet to subscribe, please do hit the subscribe button because you enjoy being a part of this family. Do take care of yourself. I know that you can always be the best wherever you are. Do take care.